starting, wasn't it? I'm pre-prepared speech option at the right timeline. We had a very pleasant drive through this afternoon, I must say. It might have been quite a pleasant spend this morning. Seems like an awfully long time since we were here in July for the last round. Some people indicate the world has changed quite a lot in that time. It hasn't changed much for us, but yes, we should see what happens. Right, so this is hearing 3, I guess, in effect, and there's a sense in which it's wash up on some matters, but also we're dealing with Whakatū Farm and Forest. We've got some residual issues with respect to Kiwi Rail and Havelock Village, and some other updates that I think that we're going to hear. So, is there any way of checking that mic is picking up what we're saying? Is anybody online? If anybody's online, can you just give an indication of whether the microphone is working?
So it's Douglas Allen here, if you can hear me.
I can hear you. You can hear us okay, Charlie?
I can hear you. It's a little patchy, so the sound quality sort of moves around a bit, but we can certainly hear you.
You're not being critical of me, are you, Charlie?
Not you at all. No, your voice is good and strong.
It was the patchiness I was concerned about. Okay, thank you. If we do start cutting out, by all means, give us a yell, and we'll try and speak up. And so, sorry. Yes. Yeah. All right, so we'll open up with Karakia. Thank you.
Tina koutou, tina koutou, tina koutou katoa. No mai, haere mai, te kouhira a tukiwa a Waikato. To tawa mai e runga, to tawa mai e raro, to tawa mai e roto, to tawa mai e waho. Kia tau ai te mauri tū, te mauri ora ki te katoa. Haumie, uie, tai e.
E te kai karakia, koe nei koa na tau hakamana e pare atu nei ki a koe. Mō I hakatau te rongomo kia marino ai nā tai e ki nei tātou, kia mai ake tū, me mihi ka tika. E noho haka honore ana I te rohe o Ōtuto Te Whirowhiro, kia kingi tūheitia ki te kāhui ariki whānui tonu. Ririrere hau, pai māriri. E hakaro ana, te hunga kua riro atu I te tai tinu, moe mai, oki mai rā, kia hoki mai kia tātou. E te whare e tū nei, te papa e takoto nei, tēnā kōrua. E mihi hoki ana ki ngā wai o Waikato tani wharau, he piko, he taniwha, he piko, he taniwha. E nā tangata whenua, e nā haukainga o tēnei whenua taurikura, nei rā mihi karere. E te tiamana, e aku kaimkomihana, tēnei te reo, nihi e pūheki ana ki a koutou. E nā mana, e nā reo, e raurangatira nā, kua ko miti, iku nei, e rere atu nei, te mihi mai o ki a koutou. E te kaupapa o te rā, e te hurihanga mahere e toru, nāu tātou I karanga, e nā te ākārati, tēnā no
And thank you, Fiona. I appreciate that. Thank you. Right. Farah, we're with you. I don't have any preliminaries. Any more? No.
Thank you. So my legal submission is really a brief 3 matters. The submission by Whakatū Farm and limited effectively rezoning, the submission by Kiwi Rail and Whanganui that were deferred from the segment hearing to enable the appeals to be resolved, and any updates with the PDP appeals that are going to variation 3. I will begin with the Whakatū but probably make sense to. And then let's start backwards.
That's all right. We're very comfortable. Backwards is good.
So So the first part of submissions for Forestry Farm deal with the scope issue. In light of the panel's direction number 12 back in March or April, the council has reassessed those two questions of scope. And council is now satisfied that the submission is within the scope of the IPI in terms of section 80E, as it's determined that the land is in fact a relevant residential zone. So I won't go into any further detail of that. I think it's been set out in my submissions. The second question on scope is whether the submission is on the variation. And in paragraph 17, I state that given the general residential zone in Horatu is now considered to be a relevant residential zone, the council accepts that the submission meets the first test of clear water. So the remaining issue is the second clear water test, which is commonly known as the natural justice test. And the case law has, a number of case law has stated that in many cases that second test will be more determinative than the first test. So at paragraph 19, I just explain why council had some took the view that it had some concerns about that second clear water test when we filed our scope submissions earlier in the year. And that was largely due to there being only one submission in opposition to the HFL submission. And in particular, it occurred to us that some of those big industries who might be concerned about intensification close to their industrial activities were not submitted on variation 3. The HFL Legal Counsel filed reply submissions earlier in the year in response to the absence of submissions, and the reply submissions focused on the fact that the land was rezoned to general residential as part of the district plan review, and of course there was an ample opportunity for the public to participate in that district plan review process. Her reply submissions also set out a number of other factors to explain why there may not have been those submissions imposing their submission on variation 3. And I've summarised the reasons set them out in paragraph 21, 8 to 21, each of my submissions. I won't go through them as you would have read them. Now, since the reply submissions for this hearing, Mr. Coventry, the Chief Executive of Te Awa Lakes, has helpfully filed evidence in support of the submission, and his evidence outlines the consultation that the associated company Perry Group has undertaken with stakeholders since 2017, and it included its decision late last year to seek a medium density zoning in respect of its land through the variation 3 process. So he outlines the consultation occurred with iwi, the Tapu Member Working Group, Horatu Primary School, and immediate neighbours. And at paragraph 23 of my submission, he sets out that consultation that the project team had with the neighbours to their Horatu West land, and I think it's important that that consultation did occur before the close of further submissions on variation 3. And following that meeting with the neighbours, 3 further submissions were lodged in respect of the HFL submission, and 2 of the further submissions, being Mr. Parker and Mr. Merritt, did attend that neighbourhood meeting in December. At paragraph 24, I also set out kind of the differences between a normal plan change process where someone wants to participate in it versus an IPI process under the Amendment Act, and that the requirements of Section 80E of the Act are not open-ended, and that was confirmed in the IPI decision. You know, the mandatory requirements are mandatory, so even if someone wanted to participate, they couldn't seek to delete those mandatory requirements or amend them in any way. So I just set out the kind of nuance with this process compared to the normal Schedule 1 process. And at paragraph 25, I come to the conclusion that, in my view, it's difficult to see how an increased number of submissions would have actually resulted in any material change to the qualifying matters or related provisions that the reporting planner is recommending to be imposed. And I'll note that of the one submission or opposed the HFL submission being Courts of Auckland Limited, they have chosen not to file evidence for this hearing. And we understand from discussions with them that that's because they were comfortable that the PDP provisions relating to the authority to acoustic overlay area have been carried through to the NRZ to zone provisions. So at paragraph 26, that's council's position that there is scope that the submission meets both of the clear water tests. But of course, ultimately that decision is for the panel, and it's open to you to require further information from the submitter if you feel that that's necessary. The submissions then move to the merits of the submission and the reporting planner's recommendation to rezone the land to NRZ2, and she's recommending one qualifying measure and density qualifying measure. What I will focus on in paragraph 34 is the outstanding issues that remain between council and Forestry Farms Limited. Since preparing my written legal submissions, I've had the benefit of reading the legal submissions filed by council for HFL, also with contemporaneous exchange of submissions. So I will depart from what's in my written submissions to just step you through the four matters that are outstanding between the parties. And I can, for your benefit, I can commit that to writing it in a reply, so you don't need to take notes. So the four matters from my reading of the Forestry Farms legal submissions is whether to introduce the flood qualifying measure now related to a future plan change, whether the proposed non-complying activities for subdivision within the high-risk area that applies to their land should be a discretionary activity instead of complying activity, whether the proposed non-compliant activity offends the Waikanae provision, and finally the wording for the proposed recommended exemption to the natural hazards rules 1920 and 21. So if I deal with the flood density qualifying issue first, I note the legal submission states that it is Mr. Collier's opinion that flooding and stormwater matters should not qualify for, should not be qualifying matter to Regulation 3, but rather dealt with as a separate plan change. I've carefully reviewed Mr. Collier's evidence and I can't find any support for that statement in his evidence. At paragraph 6.2 of his evidence, he states, I agree that where parts of the site are identified as a floodable area, particularly high-risk flood zone, then a qualifying matter should apply. So it appears that the issue is actually raised in the legal submission rather than his evidence. And the legal submissions assert that applying the qualifying matter to Variation 3 and not the rest of the district will result in an inconsistent approach to address flooding and stormwater hazards across the district. So in my submission, the application of what we now call a flood density qualifying matter, you might call it about here, it was called the stormwater constraint overlay. That was the subject of extensive expert conferencing, evidence and legal submissions at the July hearing. The rationale for that qualifying matter was set out in Council's legal closing reply of 29 September, and that the rationale for that was agreed by all the experts in the joint witness statement, and none of them resolved from that position of the hearing. So my submission of HFL had wanted to make submissions about the broader application of that qualifying matter to the district beyond its own site in Horatoru. It should have participated in the hearing 2 process like the other submitters did. The hearing today for the submission is limited to having accepted that there is scope, if is limited to identifying what appropriate qualifying measures or related provisions should apply to the site. The second issue raised in the legal submissions relates to the non-complying activity status for development within the high-risk flood area. Mr. Collier's evidence seeks that the appropriate activity status should be restricted discretionary. That is not supported by the reporting planner in her report. Again, you might recall that the non-compliant activity status for those rules in H 19, 20 and 21 was also canvassed in some detail at the July hearing. A restricted discretionary status is not considered to be the most appropriate status to give effect to the policy direction of the PDP, which seeks to avoid development in high-risk natural hazard areas, and that's natural hazards objective 1 and natural hazard policy 1. Nor does it in my submission give effect to the direction of the NPS urban development being objective 8 or the Western original policy statement as an objective 1. It was recorded in the Stormwater Joint Witness Statement dated 11 July 2023 that urban development in high-risk flood areas should be avoided to give effect to certain provisions of the WRP. So a non-complying activity status is considered to be the most appropriate to give effect to the higher order.
Hasn't that difference now been resolved by the proposed additions of the exemption?
Yes, the wording of the exemption, I understand, is not fully agreed. The reporting plan will probably provide an update on that. So, and I get to that shortly in terms of the Waikanae principle, but yeah, we're on the same page. So the third issue is related to the non-compliant activity status, which we just discussed. So HFL's legal submission state that a non-compliant activity status breaches the Waikanae principle because it will constrain existing development rights and affect rights under the operative district plan. So that's variation 3 is to the proposed plan for rights under the operative district plan and what's relevant. It is submitted and it's consistent with the submissions we made at the July hearing that there is no disenabling of existing rights in the PDP in the high-risk area under both the PDP and variation 3, one residential unit and one minor residential unit are permitted. 2 or more residential units in a high-risk area is discretionary under the PDP and complying under variation 3. In our opening legal submissions for the July hearing, we submitted that in terms of the Waikanae principle, that change from discretionary to non-compliant is not disenabling. A discretionary consent already requires consent. Our reply legal submissions for the flood hazard topic dated 29 September acknowledged a non-compliant application would be subject to an additional gateway test under section 1 and 4D. But again, our view was that the requirement to obtain a non-compliant consent doesn't deprive an applicant from the ability to apply for a consent to get 2 or more residential units in the high-risk flood area. Now, notwithstanding our view, based on HFL's own evidence, the non-compliant activity status is largely a moot point for the Horatu West land, and that's because fair planning and stormwater evidence it's very clearly of the view that the high-risk flood areas that have been identified in the Te Reo flood maps are simply follows and don't actually meet the definition of a high-risk flood area in PDP. It is noted Mr. Lester's summary statement for the Chorus block, which is part of the Horatu Farms land, that Chorus accepts the high-risk flood areas identified on their block The section 42A rebuttal report dated 14 November demonstrates that if the proposed extension to those three rules, natural hazards, Rule 1971, applies to the Horatory West land, then residential development on the site would be discretionary under the natural hazard rules proposed by variation 3, which is the same activity status as currently applies under the PDP. Yes, in that regard, there is no disagreement under the PDP. The final outstanding issue raised in the submission is the final outstanding issue is the recommended exemption to the high risk zone rules. The legal definitions appear to be final on that, but the reporting planner's summary statement dated 30 November identifies that the exemption approach is acceptable to Mr. Collier in principle, but they just haven't been able to agree on the wording of that. The reporting plan has agreed to delete the word suitably qualified person because it's already subject to the approval of council, but apart from that change, the wording remains unresolved. I understand that there was a further discussion between the reporting planner and Mr. Collier late yesterday, if she can update you on that and she gets real evidence. So I stepped through paragraphs 34 to 37. So we land at the Wapiti and Keeperell deferred submissions. And we skipped to paragraph 40. There I just report that the Council of Keeperell, Wapiti and Kainora, who was the two support party to that appeal, have reached agreement to resolve the appeals as they relate to noise, vibration and setback control. The parties agree that the provisions for the noise effect area for the rail corridor and state highways and the vibration effect area for the rail corridor don't need to be implemented through the variation 3 because they don't affect the density and therefore don't qualify as a qualifying measure. I do need to make a correction to my clause B. So the statement in clause 41B, that represented the view of the reporting planner at the time, not the party's view. As you'll be aware, sitting on other panels, Wapiti and Keeperell have consistently submitted to other IPIs across the country that non-rule related provisions and they don't reconcile from that position. The reporting planner has reconsidered that matter and now agrees that they are a related provision because infrastructure is specifically identified as a related provision under section 80 subsection 2. But regardless of the point is of no consequence because of no consequence for the panel because Golden Week's affects provisions are not being carried through to variation 3. At paragraph 43, I identify the 2.5 metre safety setback in the rail corridor, which the parties have agreed to, and that will need to be provided for in variation 3 as a qualifying matter because it may make the development designated within the NRZ zone. I don't think I need to take you through the separation of that setback from those.
No, what I was thinking of there is then and it was Tauranga, wasn't it, where in actual fact the corridor actually covers private land as well. So it's a question as to whether we've looked at that issue here. In that instance, we got Keeperell to provide maps showing where the corridor, i.e. the designation basically over that's the private land. And there were some quite significant discrepancies there. All right.
I can check with the appeals planner as to whether they looked at that. So paragraph 47 of my legal submissions identified the one difference between Kiwi Rail and council. However, that paragraph can now be struck out because the council, Whanganui and Kiwi Rail have now agreed that the setback to the regional arterials and the assessment criteria that went with that can now be deleted from NRZ to standard 15 because it doesn't qualify as a qualifying measure because regional arterials are not significant regionally, not nationally significant infrastructure. And that deletion addresses the concern raised by Mr. Allen,
Yep.
legal submission for as well.
So it wasn't, I think in his words, he asked whether it was intentional or accidental. It was just which one of those.
I was there for a good point, but it can be deleted.
Yeah.
So that takes us to the new site-specific policy support for the 2.5 metre setback from the rail corridor that's been agreed. It's between council and Kiwi Rail. But that new policy support is opposed by Pioneer and its legal submissions, and they oppose that on the basis that the existing district-wide policy, which is all of infrastructure policy, 27.C, provides sufficient support for the rail setback within each chapter. And it kind of also raises concern about plan interpretation issues as to why there's no net objective of policy in the other zones that are traversed by the rail corridor. In my submission, that concern is respectfully overstated. The MRZ zone can be distinguished from the other zones because it is the only zone that is subject to qualifying for 313 development on the site. But arguably, a setback is more important to an NDRS developed site than a site that might be one dwelling as the risk is increased with more colours.
It can be, but does it need to? I think it's more the question. I mean, the policy in the infrastructure chapter is, the land transport network is defined to include rail, so it's clearly included. I guess the question is, Topham's razor, we really need it. If we don't need it, why would we have it?
The reporting plan of view remains that it is appropriate to provide that clear cascade between the objective policy and the standard, and that the absence of that separate specific policy of the other zones doesn't undermine the standard for interpretation issues. The next outstanding issue is policy 11. So the amendments to policy 11 are again agreed between council and Kiwi Rail, but the amendment is opposed in line with its legal submissions on the basis that the rail setback control doesn't seek to manage reverse sensitivity effects. Instead, it manages the efficiency of the network and safety concerns, and that the supporting rule is not yet included in the PDP. However, that's simply a matter of timing in terms of whether consent for this issue. In any event, the reporting planner in her summary statement of 30 November identifies two other standards in the NRZ zone that do require the use of design controls to minimise reverse sensitivity effects. And so hence the proposed amendment does give policy support for those standards.
The other argument there was the I think it might be Mr. Campbell's argument, wasn't it, which the suggestion that confuses safety with sensitive. So comment on that. I think his point is that this is a reverse sensitivity policy, not a health and safety or operation.
It is headed reverse sensitivity, but the rules that the reporting officers identified do address, I think they were MRZ standard 18 and a standard in the Havelock Creekside provision. They do specifically address progressive disability. And it may be that the wording can be clarified to address that concern of Mr. Campbell, and I think that's information. So that brings us to the end of the deferred submissions for Kiwi Rail and Whakatane. That just leaves an update on the PDP appeals that are relevant to Variation 3. So you will be aware from the memorandum filed by Ms. Evatt for Havelock Village Limited that consent documents resolving that appeal was filed with the Environment Board on 30 November, together with a request for urgent consideration by the board. The consent order has not yet issued, but we did receive a minute from the Environment Board this morning. The minute stated that the board is inclined to grant the consent orders, but it just seeks a clarification on the location of an assessment criteria for engagement in each of the subdivision stages, and whether that assessment criteria is impacted by any of the other PDP appeals. It's certainly not impacted by any of the other PDP appeals because it is assessment criteria specific to the Havelock precinct, not just applied. So the intention is that the parties will file a written memorandum with the court providing that clarification, and the expectation is that the consent orders will be issued. So in response to the panel's helpful minute from on Friday, a joint witness statement from Mr. Tomarsh and the reporting planner was submitted, I think yesterday, and that is conditional upon the court approving the rezoning, but will enable the remaining provisions to be considered as part of your consideration. And on that basis, the memorandum from the Evatt asked that the hearing not close at the end of today, but remain open to allow consent orders to be issued. There's a couple of other appeals potentially in that category which would benefit from the hearing remaining open. I think in the initial one to see you indicated that it possibly remain open until the end of January. So the other appeal in that category is
of course, it may stay open even longer depending on what government decides to do over the next 100 days.
yes, well, this isn't a 100-day program, so timing for that is yes, uncertain. So the other two appeals.
Can I just check in terms of that issue that the court has with the assessment criteria? Are those assessment criteria anticipated to come into the provisions for our IPI, or the standing, or they will come in simply into the PDP?
I will need to check that. In fact, Ms. Evatt might be able to do that.
Yeah, no, she's listening, so she can address that when it comes. I mean, I'm particularly interested in how far do we need to go as opposed to what's going to come through short.
So the other two appeals is the submission to Variation 3 by GDP Property, which is the appeal that is the name of the landowners, which is us. And that relates to the property at 111 Howard Road. The consent documents for that, and that seeks a rezoning from rural to general residential zone. The consent documents for that have been prepared and are close to being filed. The other appeal is Greek Holdings Limited, and that seeks rezoning from large lot residential to general residential zone in relation to two sites on Johnson Street and Toycow. That's a further technical work as to advance that appeal. Council proposed to getting a number of the accountants, technical reports, peer reviewed. So those two appeals will also benefit from the hearing.
But I think you indicated that it's unlikely that latter one would see the light of day before we close.
Yeah, in terms of end of January, it may be too late, but certainly I would expect consent orders to issue for arts before the end of January. And for arts,
And that's the Harrisville one. Is that the Harrisville one?
it's 111 Harrisville Road, but not to be confused with Harrisville 23 Limited,
Yeah,
which is also on Harrisville Road. I can't remember the number of that, sorry. The arts one,
Not to be confused with it, we don't know where it is.
Yeah.
Yes, right.
the arts appeal would simply be including it in variation 3 to be rezoned to MRZ2. It doesn't require any qualifying medical related provisions because the controls that have been agreed as part of the appeal relate to things like acoustic and noise and acoustic insulation. They don't affect density. That's just affect that straightforward.
So that's just a mapping issue.
Yeah, it may be that a joint planning witness statement is even required to be submitted for that one. This is in further questions. That's overview.
A long day, right. No, apparently not. Further questions from Karen?
On all this holding, so it's the expert evidence and assessment fees. Have not village land, in terms of your assessment as to whether it the land constitutes the relevant use.
And the conclusion is it does, so that's the end of that conversation. Was there anything else? I mean, we've read the material and it's very comprehensive. So thank you very much for that, but we don't really need to reprise all of that detail. So, was there anything else you want to tell us?
I've just got 3 points.
Right.
Make you just things to be aware of, I suppose, since this evidence was written quite a few months ago now. Okay, since the evidence was written, the RP's decisions on plan change 1 have been released. So they were released end of October. So we're during the appeal process for that. And probably before you issue the decisions, the appeal period will finish. So just sort of making it aware that there were some changes to as part of the release of the decisions, but in my mind, they don't affect the conclusions that I've reached.
That's handy. Very lucky.
The second point relates to Te Awa Lakes, and I just wanted to acknowledge that the Lakes development is on both sides of the both Hamilton City and also within Waikato District. And within the Hamilton City side of the Te Awa Lakes development, there is a community and commercial centre proposed. And I just wanted to draw your attention to the definition of urban environment, which talks about regardless of size, irrespective of the territorial authority boundary. So I just wanted to sort of make that point. The other point.
So that qualifies your concern about Fortitude and not
Yes.
having a small.
Third point was just relating to the 2017 structure plan. So the structure plan was called the Ngarawapia structure plan, but it also included Horatu in that. And there were some conclusions that were reached regarding that they were on page 13. I just wanted to draw your attention that those conclusions are still current. The council is revising the structure plan at the moment. Structure plan has been completed, but that structure plan does not include Horatu.
So you want to draw our attention to the conclusions of that, but you're not going to tell us what those conclusions are.
Oh, they're on page 13.
Okay,
I can,
read it, you lazy people. Is that what you're saying?
I can go through them if you like.
And Tony, if you just encapsulate, just very briefly. I mean, does it take us somewhere different? This is the question.
No, they're in, it's on paragraph 28 and 29. It doesn't take you anywhere different, but I just wanted to draw your attention that we do have a structured plan process that's going on at the moment, but that's not going to change anything there because it doesn't
They
include.
are contradictory.
No.
Good.
So that's all.
Thank you. Great. Welcome again. And you're going to be short and sharp to the point. Excellent.
So in the first hearing that we mentioned that we were going to take a couple of QA, that's done. I said that we're expecting to see major changes from the results. And that wasn't the case, which I'm happy to say. We managed to go through the models in a lot more detail. It's a lot more time. There were a few minor tweaks to call it plotting to be really throughout the models. And yeah, I changed a few little bits and pieces on the outskirts. But those areas, just really, if you guys have any questions.
Thank you. Modera. Nigel.
Yes, there was some discussion of various bits of evidence that the flood density maps were going to be presented at the hearing. I haven't seen them. They actually been produced, the latest maps that incorporate your modelling, but are going to be in the plan as the flood density maps. Are they available for us to look at?
So the updated maps that I think the data were submitted to.
Yes, there was that through.
They're in the back of those the modeling reports.
Oh, okay, those ones. Okay.
So you should now have the modern reports for the four
Yeah,
additional
yeah,
maps.
yeah. So the maps on the back of that. Yeah,
Yes.
yeah, back.
Yes, there was a report of these maps.
That's the modelling report, final 3 November 2023.
Yeah. I did have a question in your paragraph 12 of your second statement of vital evidence. I think it was in response to Havelock land saying that floodplain and overland flow path need to be defined. And your comment was that they're both defined in the modelling report as areas greater than 0.1 metres depth and covering more than 150 square metres. So is that the same definition for both overland flow path and floodplain?
Yes, it is. That's the,
I mean, does it make any particular relevance? Because I'm not sure that the maps talk about the floodplain and talk about the 1% AEP at their level. I guess my question is how significant are those, finding those terms at this stage?
the type of modeling going to talk is brain on correct. So that picks up the overland flow paths once it gets to that certain depth. So that's why it's the definition of the overland flow path, as well as those modeling areas and other areas. So it's the sort of all into one, like more brain on correct. We're kind of gone into details of defining overland flow paths, all of them, but they are included in what's shown.
They are shown. So I think your comment and your evidence was that you didn't, that the definitions of those in terms of being on plan will come with the proposed future plan change for flood hazards. So this is very much an interim measure. You've got your maps now that show the flood density. So in your view, that's the sort of best that can be done at the moment.
And I think in terms of your overall conclusion was that provided the exemption clause can be properly written, then you're comfortable with it.
Yes.
And are you part of the loop of deciding on how that should be expressed, or is it solely city planners?
Okay, that's what it is.
Yeah, okay. I mean, obviously it needs to be looked into once any disagreement or agreement is reached. Well, no, we don't want disagreement reached. We want agreement reached. So once agreement is reached, then presumably you cast your eye over that and make sure it makes sense. in your terms. Yeah, okay. Think so. Thank you.
So there's another one, just on this mapping, sorry,
Almost.
on the mapping that's going to be, I understood they're going to be called flood density QM maps. The maps, looking at your Horatu report, updated maps, well, it's October, sorry, it was November one. They're not actually headed up with that title, are they?
So we've also provided shape files, and my understanding is that the shape files will be processed, so the WRC flooding areas plus this flooding areas will be presented to the overlay for the.
So the map that's going to go into the plan has not been finalised yet. It's going to incorporate your flood maps plus the WRC.
You want to see a specimen?
Yeah, I'd quite like to see it.
We see a specimen of that. You run whatever it is, and just produce one so that we can actually satisfy ourselves that we think the best job we should do.
So that process is not going
Yeah. Well, whoever does it, not really worried, because if we just cite what it looks like, and then if we've got any comments on that, we pass those through. Good. Can you go in that motion?
And harking back to the previous hearing with the notes and the expert evidence of Matthew Davis, there were a whole lot of provisions, quite a number of provisions that they suggested. And I think in the evidence, the council's closing for that hearing, it referred to the notes, but then it just came down to a few recommendations in terms of the provisions. So I guess my question is, are you happy that the issues that were raised, particularly in the evidence of Matthew Davis, in terms of this matter of downstream channel erosion, particularly in rural areas, are encapsulated to an appropriate degree in the provisions now?
My concerns with the wording of that was that they were wording it in terms of volume, duration, and frequency, and to match existing pre-development.
Certainly, I understand that we can't, that's not acceptable, but I'm more genuine in terms of avoid and mitigate those effects. I'm happy that there's sufficient in there to address that matter. It can be done to the extent practical.
Yeah, I don't think that those changes have added much more than what was already in WRC guidelines. And I think that they were managed in that way. So
But I think just on that thing, I think there wasn't a resolution, was there, between Mr. Davis and everyone else on the way in which that provisional rule, whatever it is expressed.
there wasn't a meeting where we took out a lot of those frequencies, duration,
Yeah.
and wording. I'm not sure whether actually the discussion.
Okay. Right. Where are you taking us? Sure.
I am. So I will skip over all of the summary of my recommendations. I'll just focus on the outstanding matters, and I'll also try and answer some of the questions.
Thank you.
So straight to the recommended exemptions.
Sorry, can we just get you to speak up? It's a little bit hard to hear.
We've got
You've gone.
the overhead fan is down
I
here.
understand.
Yeah.
I am good at speaking well. So I recommended that an exemption be included to those natural hazard rules that potentially trigger the non-compliant issue for consent for forestry farms. Ms. Collier and I had a number of discussions around what the wording of that exemption should be. So in my summary statement, that's sort of the latest version of the exemption. It's quite to the point. The only issue that remains is whether that hydraulic assessment should be subject Mr. Collier is of the view that it can just be submitted and there isn't sort of a requirement for council to then approve it, and potentially can review, peer review, and determine if it is or not. And my view is that yes, it should be at council's discretion. The main reason for that is that it is high blood loss that we're dealing with, and it's essentially a non-compliant requirement. There's strong policy directives that are actually related to avoiding any development in those areas. So any potential applicants that are suggesting that their land or they have a particular piece of the site that is not in a high risk flood area, that should be subject to someone actually scrutinizing and double checking that it's correct. So that's my reason. I think if there was, if the exemption was in there, but it wasn't to be subject to council approval, I would support an exemption for those reasons.
Well, I guess the only other way would be to have the suitably qualified person actually be approved by council, which would be the other way of doing it. That would, and that might resolve both of them, for the fact that that's the case. So you submit the qualifications of the person you intend to use, council says, yeah, that's fine, we accept that. Where you go.
That would be an option.
Yeah. All right, we'll have a think about it and come back on that. I mean, I agree with you. I mean, if the person is suitably qualified, then second guessing seems a bit unnecessary. But I also accept the point the council is the last person standing on this particular issue, and therefore does need to have control.
And then in response to your question, Mr. Hill, whether the exemption does address that non-compliant activity status, and in my view, yes, it does, because it will pull it back down to discretionary. The next topic is that I wanted to talk about was the objectives and policies for railway corridors. In my 42A reports, I state that I am supportive of the both objectives and the policy for the railway corridor setback. I do acknowledge that they are already existing in the infrastructure chapter, not quite as specific, but they do come to the same outcome. In my view, it is helpful for plan users to have the objective and the policy sitting in the same chapter as the rule, and it does provide for that policy cascade. You don't need to go searching in the same, find that objective and policy that actually support that same. That's the main reason for that.
So is it your understanding now that there is complete agreement between the three parties on the alignment of policy 11 and your on the versus to it, and policy 16 on and 17 on the railway corridors? It's a question for as well. They've sorted themselves out, so there is that sort of one alignment. There's no mixing up between the reverse sensitivity and the setback.
I don't think there's agreement from the parties in terms of standard 17. So standard 17 is the requirement to set back from the rail corridor. And then policy 11 is the reverse sensitivity. So trying to order our review that through the appeals process, it became quite clear that the reason for the key rail setback is for safety and efficiency of the railway operation, and not the reverse sensitivity. And that's their justification as well for saying that actually Kiwi Rail, there should not be an amendment to the policy 11 that's supported by Kiwi Rail that provides for building standards to be used to address reverse sensitivity.
Yeah, so it's sort of not.
So the amendment to the policy 11, so reverse sensitivity policy, does give effect to standard 18, sorry, which is a horizontal acoustic area. And also, and Havelock Precinct is another acoustic requirement that requires more usage. So there are other reasons for including that policy.
just a small typo in standard 17. 1A, in your third line, you introduced a musical half note. Introduced a minimum rather than the minimum. So it's a minor one.
I believe I copied and pasted that from the draft consent.
It's longer than that. What's it become?
Well, if it was longer than half note, it would be a whole note. Right. Right. Moving on. Thanks.
So, Carol, you did have a question about whether there might be confusion between the safety.
Well, it wasn't mine, it's just Mr. Campbell, somebody actually had made a note that in his opinion, you appeared to conflate safety and reverse sensitive. So just a response.
Okay. So standard 17, which is the railway corridor setback, there's only one matter of discretion to do approach into the setback, and it's very clear that that's not at all related to reversing something. So I think any reasonable plan user would go looking at that reversing strategic policy to try and justify anything related to a railway corridor setback based on the matter of discretion where it's there.
Just one more question on standard 15 on the building setback. Sensitive land uses.
Yes.
You've still got to put where on the first area of discretion. Is that correct?
That has since been solved, be it very late. So in my summary statement, that standard was sort of lumped in with the appeal, but it wasn't subject to the appeal. So it was sort of blanked out as part of a early considerations, and then it was sort of left hanging on its own. In the summary statement, I outlined that because it's regional structure, it doesn't meet the.
So it's shown it's struck out, and that's what you agree with.
Yes, and the latest set of recognition was struck out. I was going to give a summary about Havelock Village or Havelock Precinct, although I wonder if that's their step two.
Just before you go there, and I can't recall, I'm just looking at strikeout number 7 there, which was the 6 metre from the central gas transmission line, and I know there was a conversation about it somewhere in someone's evidence. What, just remind me what the issue was there? It was in, then it was out.
The issue was that First Gas appealed the provisions, and as part of their appeal, they had not included the general residential zone. So they then could have required that 6 minutes setback. That's only due to Waikato. My previous evidence, I said that I would still support the 6 minutes setback to the gas line if Waikato wasn't.
But for Waikato. Right, okay. All right. Yes, because we've had the same issue with First Gas. Yeah. All right. Sorry, you were going somewhere else now.
It kind of was, the Havelock.
Yes.
So, Tomash and I provided the joint witness statement. I was going to provide a summary, but I also think that that might be best left to the Havelock team. Specific question about me.
No, for me, the issue is just the translation between what's coming through from the court and what we need to do, and whether that's one and the same or it's different. I just need to understand what we can do as opposed to what we can't do. We'll have the conversation instead of that.
And I assume, I think it's, we were told that the draft consent order had been filed. I assume that all parties have signed up. Sometimes you file this consent orders and not every party signs up.
All
parties
sections
have some.
It's pretty good unless there are only a few parties, I suppose. Okay. Yeah. All right. That's it for the moment. Thank you very much. And just for the record, note that Mr. Lester's planning evidence is tabled. So now,
Commissioner Cole, Ms. Cole is going to provide an update on a couple of the
yes.
outstanding appeals. Sorry.
by all means, yes, thank you. Yes, you have to do your own distribution.
So after the hearing in July, there were 3 outstanding matters that I identified with respect to the Harrisville 23A exhibition. And those are outlined in paragraph 2. And this one being infrastructure capacity, the second one a qualifying matter relating to geotechnical constraints, and the third one relating to the consultation with Ngāti Tamaoho. In respect of the first matter, I should say that Vanessa Elliott and I both written the statement. In respect of the first one relating to infrastructure capacity, I've had further discussions with Mr. Talpa. And as a result of that, we are now confident that the servicing of the site can be considered at the time of subdivision. And at that time, there will be some further discussions to be had about the actual capacity that's available then. And paragraph 5 here, both Eddie and I acknowledge that there's greater clarity. And whilst we note that infrastructure is not an impediment to rezoning the site, it's important to acknowledge that it may not be sufficient infrastructure for a full NPRS type development on the site. So, in respect to geotechnical constraints,
But we don't need to be satisfied about that. We don't need, it's not a requirement on us to be satisfied that there is the fully developed to NPRS standard on the site.
that's right. In respect to the second matter to do with geotechnical constraints, in an email dated the 2nd of October, Ms. Eddie on behalf of Harrisville 23 stated that Harrisville 23 was accepting of a qualifying matter west of the building line restriction, and I've attached to the end of the statement here, appendix 2, a map showing the location of the qualifying matter. And paragraph 6 to 9 are just sort of outlined there that the qualifying matter relates to natural hazards, and it's based on the evidence of Mr. Tilsley and also geotechnical report that was attached to the 2014 Tuapo structure plan that identified that geotechnical issues are in fact an issue around this area of Tuapo. In paragraph 10, saying based on Mr. Tilsley's comments and the risk assessment, he'll consider it appropriate for a qualifying matter to be applied. Ms. Eddie also agrees with the additional qualifying matter, and the qualifying matter will apply to that part of the site west of the building line restriction shown on concept plan. it's sort of clear from the source there's evidence that that part of the site isn't very suitable for development or those geotechnical issues. If the commission has agreed, there's some proposed amendments that I've outlined here in paragraph 11. I believe the policy and an amendment to MRZR2. Third matter relates to consultation with Ngāti Tamaoho. Addie has tried on a number of occasions to contact Ngāti Tamaoho about the rezoning of the site. There was a consultation that has occurred, which outlined paragraph 13 relating to the subdivision application. And whilst no further contact has been possible with Ngāti Tamaoho, Fiona Hill notes a number of recommendations as part of the subdivision consent, which are currently on hold, will be considered as part of future consents that are required from the Waikato Regional Council and Waikato District Council. And these consents include stormwater discharge consents and other consents from the Waikato Regional Council. So on the basis of these matters now being resolved with satisfaction of Ms. Hill, the submission to rezone the land to MRZ2 being relevant residential zone at 23 Harrisville Road is recommended to be accepted. I'll show the amended map and the location of Kiwi.
In relation to the geotechnical construction, lot 19. Lot 19. Where the plan been amended, the numbers.
Yeah, this may be an older version.
I thought it was one of the ones where that valley comes in. And they look at you think. It's not referred to in the rules.
Yes, we've had a few changes to the plan.
Yes.
That may be a more recent update, but it will be on the land to the west.
Yes.
Yeah.
Do I have anything to say?
No,
Wouldn't make any sense with a further recommendation.
that's right. No, other than I appreciate the collaborative approach.
No. All right. Thank you. Good. Sometimes silence is the best cause.
Thanks very much.
Thank you.
Now, of course, this doesn't mean that we necessarily accept it. Just be very clear about that.
Oh, yeah, no, just say that.
Be very clear. Yeah, thank you for that. All right.
Just have one more update. Since the last hearing in July, council's been working on a mechanism to show the flooding maps outside the plan. Remember the debate about inside, outside the plan? And we're now confident that we can have a system to display the maps outside of the plan. So I just wanted to make you aware of that. Ms. Davis Miller is here. She's been working on that. So if you have any particular questions related to the work that we're doing, then she would. Just wanted to make you aware that.
Yeah. Thank you for that. And no, I don't imagine we have any. No. Do we have any clarity on when the court is likely to hear and determine that the Tauranga issue of the non-statutory maps? Right.
I'm not.
All right. Thank you. That's it? Yeah. Thank you very much. Right. Who have we got next? Kiwi Rail. Right.
Good
Right.
afternoon. Kia ora. Good afternoon, everyone. My name's Kristen Gunnell, and I'm appearing as legal counsel for Kiwi Rail today. Ms. Butler is also online, but she is currently en route at the airport. But I'm hoping that ours will be a short presentation just to update you on where.
Yes.
Excellent. Fantastic. So my legal submissions were pre-circulated, and I just proposed to give you a short summary and also update you on some conversations around the reverse sensitivity policy. So I guess just briefly to confirm where we got to on noise and vibration, you will have been aware that in the district plan process that KiwiRail was engaging with the council, Waka Kotahi and Kāinga Ora with respect to the Waka Kotahi and KiwiRail appeals, and that appeal was very focused on noise and vibration provisions and for KiwiRail the setback standards. And I think you will have seen through the documentation that we're very pleased to report that resolution has been reached, and that was after a lot of time and meetings and resources by all parties. So that's an excellent outcome.
It's amazing how much it takes to reduce 2.5 meters, isn't it?
Yes, it is. Every centimetre was considered. So just to clarify with noise and vibration, they will sit in the district-wide chapters for the PDP, and all parties are comfortable that they will then apply to the chapters that are subject to variation through by virtue of that district-wide application. And so I don't propose to focus any more on noise and vibration, but I just would like to record for the record that KiwiRail, and I understand Waka Kotahi, don't accept that noise and vibration provisions aren't related provisions. Our position is that they could be related provisions under Section 80E for the purposes of MDRS, but given the way that they're being applied, we don't need to go into that detail there, but did just want to note that although I understand that to be council's position, it is not the Transport Agency's position, and certainly that is consistent with our submissions and our relief sought in other MDRS plans around the country.
So do we need to make a finding on that, or is it the position of both council and yourselves that no finding would be better than a finding?
From my position, no finding would be better than a finding. From a practical perspective, it does not matter. The district-wide rules will have effect in the MDRS zone. We would be happy to present written legal submissions on scope and why we consider noise and vibration to be within scope. But from a practical perspective, I submit you could make no finding on that, and you know.
Yeah, we're happy to make no finding, I'm sure. Yeah.
Fantastic. Excellent. And as you've indicated, with the setback controls, KiwiRail has agreed 2.5 metres for residential and 3 metres for non-residential. And I think in everyone's evidence, we've requested the panel to apply that within the zones that are subject to variation 3. And you know, I think you'll be well aware that the setback is a safety control rather than sort of a noise and vibration control. So they are two different mechanisms, and they do sit in different places. And so the setback control does need to sit within the chapter, and so it would need to be included in the MRZ2 chapters as proposed by the council planner and Ms. Butler's evidence, and in the evidence for Kāinga Ora.
Good.
Excellent. So I think that brings us to objectives and policies, which are probably the only elements that are still up for discussion amongst Kāinga Ora Council and KiwiRail. Firstly, just looking at the reverse sensitivity policies, and the document I have in front of me was the council planner's attachment 1 to the summary statement of evidence, which I understand was circulated to the panel last Friday or perhaps on Monday. And so I guess just to confirm from KiwiRail's perspective, and I'm looking at MRZ2 objective 6, and I think that's page 14 on the PDF version. On a printout, unfortunately, I don't think there are page numbers, but it's objective 6 within that MRZ2 section. So just to confirm that KiwiRail accepts the council planner amendments and is happy with that updated wording. KiwiRail's, I guess, main concern with the objective and policy under reverse sensitivity was that there wasn't a corresponding reference to design measures in the policy. So the objective talks about design, setbacks and building heights, but the policy, which is policy 11, only reference setback distances and building heights. We discussed with the council planner, who accepted that it would be beneficial to include reference to design in that, and she proposed amended wording that KiwiRail had agreed in her 14th of November statement, and then has included that in her updated statement for the hearing. KiwiRail did discuss this with Kāinga Ora to see if we could reach agreement between the parties after reviewing Mr. Campbell's evidence, raising issues with that wording. KiwiRail understands that Kāinga Ora's concern is that the design inclusion was broad in his application and wasn't specifically linked to a identifiable standard within the chapter, and they wanted to see that link between the rule relating to a design measure and the policy. From KiwiRail's perspective, we would be happy to accept a more specific amendment to that policy. We are equally happy with the council planner's phrasing and have communicated that as was set out in the rebuttal statement. We did agree specific wording with Kāinga Ora, which we would be happy to circulate to you for review, but it effectively states that sorry.
No.
Oh, cool. Oh, sorry, I think there was a little bit of feedback. So the wording we discussed with Kāinga Ora was to manage potential reverse sensitivity effects by use of design controls for sensitive land uses in the Havelock precinct. I also understand, after having reviewed the supplementary statement, that an acoustic control has been agreed for the Horatu area, and so although the wording we discussed with Kāinga Ora refers to the Havelock precinct, that would be updated, and I don't think, though I would leave Kāinga Ora to confirm that they wouldn't have an issue with also including reference to the Horatu standard in there as well. So I guess from KiwiRail's perspective, we are very pleased that there's a reference to design measures in the policy. We think that's appropriate to ensure there's a linkage between the objective and the policy. We would be happy with either the broader wording proposed by the council planner or with the more tailored wording that we had discussed with Kāinga Ora.
Right, okay. Well, certainly let's invite you to submit that through, and Ms. Parham, maybe in your reply on this one, you can wrap that all up and we might have an agreed form of wording at that stage.
Cool. And then I think just on the remaining objectives and policies, KiwiRail is very happy with the proposed new objective policy relating to setbacks from the railway corridor, objective 10 and policy 16. And so we support that inclusion as proposed by the council planner. And for completeness, our other submission in respect of objectives and policies was with respect to the deletion of residential in policy 6. And our understanding is that certainly the council planner is happy with that and has included that in the supplementary statement. And we don't understand Kāinga Ora to oppose that. It wasn't mentioned in Mr. Campbell's rebuttal evidence. So hopefully there is no disagreement on that point. So yeah, that I guess wraps up KiwiRail's outstanding points that were within the scope of this reconvened hearing. Did you have any questions on any of those elements?
I just think it'll be useful to see those final words. Make sure a clear flow with various has been checked off. On setbacks and reverse sensitivity, it's not clear in my mind that there's a clear flow through each of those at the moment.
Certainly.
And yes, And presumably, if Horachue is to be included in that cascade, Sparabicino should be involved in that circulation, just to make sure that she's comfortable with whatever the wording is. Oh, there you are, right. Yeah. All right. Now, does Ms. Butler have anything to tell us, or is she racing off to fly, and that's fine?
No, I think unless you have any specific questions for her, she's very happy to to maintain a listening brief.
No, I think, I mean, you've told us what you need to tell us, and I think that's it.
Excellent.
No, well, thank you very much. Appreciate your time.
Excellent. Thank you very much, all. Have a good afternoon.
Thank you. Horachue, thank you. And I just know this is going to be one of your briefest appearances. Yes. And apologies for not getting to you earlier about the deferred start for the day.
That's right. And if that's a quick go, good afternoon, everybody. This will be brief. I've been able to read the submissions from Ms. Harnham that will be circulated, and I understand the committee's read both sets of submissions. And so to summarise, my suggestion would be that I just focus on the areas that remain of difference between us, which are related to the factual evidence. And I just want to also concur with the previous comments on the last submitter, that I just want to commend the council and legal counsel for having such a pragmatic and collaborative approach with dealing with matters such that what's before you is focused really on the points of difference and being open-minded, because that's particularly important given this is new legislation that's been a moving feast.
I think open minds are just,
Wonderful.
they're overrated.
That's where we're going to differ. Moving to the points of difference, it appears that what's remaining sits with the planners, but really relates to the aspect of the engineering and flooding. But in my submission, I do think it sits with the hearings panel around, in my view, which may be a legal interpretation issue, but it's about the element of risk that sits in that area of flooding and how at a policy stance that should be addressed. And in listening to what's been put forward by the council, I think where the difference lies in the engineers, and it's flown through to the planning response, is the focus that I think the council has is on the avoidance and the extreme consequences rather than the factual engineering evidence around the likelihood of it. And in my submission, that's also underrated the evidence of Mr. Atkinson that the modelling that's been done has applied an 80% impervious urban redevelopment over a site that's greenfield and undeveloped. And so when the two have been imposed upon each other, there is a assessment that's come out of high risk, when in fact that is in fact a low, very low likelihood, given that the land is going to be contoured extensively. And the other aspect of that is in an urban area, the importance of stormwater flooding management, and the management tools that are there for flooding are extensive, and the expectation of my client, as would be expected in most resource consent processes, that there will be a requirement for extensive engineering and a report. So if I could just summarise the difference in Mr. Collier's evidence without wanting to limit when he speaks, but I think that the difference there between Ms. Lectois and Mr. Collier is that Mr. Collier's position is that an expert engineering report will be included with a subdivision consent. The expectation through the RMA is that if there's any part of that expert report that is inadequate in terms of the information that's provided or the quality of that information, it gives concern to the council that they have the ability through the Act itself to get that peer review. So it's the question of, is it appropriate to preempt that in some way through the policy? And in my submission, it is not. In my submission, looking at this from a policy framework, it is appropriate that is an RDA criteria, not a non-compliant or discretionary one, because of the nature of this being very limited and very specific with an ability to have a technical approach to it.
So the objection is not whether council has an approval role, and this is just a matter of how it's expressed.
Exactly.
So as long as the policy is written in such a way that it seems to imply that the landing of the report is the final deed, then that's fine.
Exactly. So that summarises the key issue between ourselves and council that I see is outstanding. And if I could now, perhaps my suggestion is, and first I just wanted to state that Mr. Coventry wasn't able to attend, and Mr. Lallier is here in the stead, but he will answer any questions on behalf of the group.
I haven't seen you for a while. Oh, yeah. Yes.
But other than that, my suggestion is between the experts that are in attendance, between Mr. Adamson and Mr. Collier, is that perhaps if the commissioners have questions, that you direct those to the particular expertise that are here at the table, rather than formally going through the evidence. Is that acceptable?
Absolutely. That might be very short. Nice one. Would you like to kick off? Or are we going to hear from experts? Oh, okay, straight in. Okay. Do you want to do just a warm up in that case on the
Okay.
issues?
So, Mr. Collier, if you
Very
would
briefly.
just talk to the differences between the secondary array.
Yes, certainly, and I think I know from the panel. So my name is Aaron Collier, I'm a consultant panel. My qualifications and experience are set out in my evidence. And I must say it has been a very useful process to be able to work through these issues with the council to get to a point where I think we're pretty close in terms of the one outstanding issue, which is in relation to this exception. The way I see the rule working is that the rule will be applied at the time of the resource consent. So when you're developing a site like Corritac West, obviously you go through a kind of a process, landform design, stormwater civils, etc. And so that work is done, and the current modelling that's been sort of applied across the landform is a little different, because normally you deal with an undeveloped kind of rural piece of land, you run a flood model across it as a pre-development scenario, and then when you do your development landform, you would rerun that model and look at those effects. So what we've ended up with is a bit of a strange situation where you've got humps and hollows, and we've applied an impervious surface control, for example. So logically, in those humps and hollows, they ended up in water sitting. So what I've suggested is that the exemption rule basically says something along the lines of this rule does not apply where a detailed hydraulic analysis demonstrates that the site is not within the definition of a high risk flood area. Now, and just I suppose building on Commissioner Hill's comment earlier, you could include a provision in there around that being a person accepted by the council in terms of being a recognised flood modeller. So I wouldn't have any concern with that. What I did have a bit of a concern with was an automatic provision that required the council to kind of review that. And I don't agree with that approach, because I think we've got certainly qualified and experienced engineers in particular. Their work should be accepted and acknowledged as part of that process. So that was really the only point of difference that I had with the council. I think if you end up writing a provision like that, then there's an automatic signal to a consent planner sitting somewhere in the future, processing that consent, that they've got to run off and get an automatic peer review. And I wouldn't like to see that necessarily be the case. I think the suggestion around that person being effectively pre-approved is okay. But I don't think that the council needs to have a kind of an overall discretion, because we've already got that under section 1 and 2 of the RMA anyway. And so if an application is made, is the ability for council commission peer review for anything, whether it be stormwater modeling, traffic. Or whatever.
Is there a definition in the plan for SQP? Some councils do have definitions in their plan whereby that's a certification process stuff. All right.
Sometimes it's in the development code as well, so it's outside the plan, but they have, the council will have
Yeah.
the expectation of the categorizations of the engineers.
But my general thoughts, having read all of the evidence and having worked on the land for a long time, I don't think it's going to be too much of an issue.
Yeah, but the rule doesn't just apply to you guys.
That's right.
It applies right through, so we need to be thinking broader than that. Okay.
Sorry, there was just one thing legally, and it was really factually, you asked about the page 27 hearings. We have a judicial conference tomorrow on it. It's likely to be heard in the middle of the week. I would say that there's like, at the moment, there's probably only one appellant that's arguing whether or not it's appropriate to have the maps sitting outside the district plan. So, not my comment. That's all.
All right. Well, that's not going to be resolved before we finish this process. So thank you for that. Just wait to see the law. Yes, that's right. That's right. Yes. Yes, we'll see what the final words are.
Yes, but just a comment, Mr. Collier. So I get you, what you're saying is you don't want council to, in the future, to automatically require a peer review in the case of a report that's done by a sort of qualified person and that's sort of dotting the i's, cross all the t's. But generally, council does have a review capacity, so it has to certify, if you like, or say, yes, we're happy with that. So, correct. With how that is done.
Yeah. And what normally happens is if the council's got any doubts or concerns, they can commission their own assessment under section 92 or require a peer review. And that's a normal approach, as I say, whether it be traffic or stormwater or any kind of technical system.
I mean, we can wordsmith this to death. I mean, immediately just coming out of what you're saying there, Nigel, I mean, I'd reframe that in terms of council determining that on the basis of a report that it's within the definition. I mean, there's a different way of doing that. So let's let you guys wordsmith the final version. And if there's only, if there's 2 or 3 versions that come through, we'll give it to us and we'll tell you which one we want. Okay. But understand the issue. Anything else? Thank you.
So next, Mr. Adelson.
Yeah, my name's Justin Adelson. I'm a civil engineer. Qualifications and experience made out for evidence, but essentially I've been servicing the site and wastewater water supply. So I'll briefly give a brief update and start with the easy ones, the wastewater and the water. So there's been a number of reports over the years done by the District Council, as well as the developers and the developers of the area as well, infrastructure capacity on a wider district scale, and a number of upgrades have been identified within those reports to service the wider and quality area. So we've had some discussions with the Waikato District Council and board here on some issues, and the growth of the West Block needs the growth of the rest of another way here, and the timing for these upgrades are probably key and for supply to cycle for them. The stormwater, I probably won't go into too much more detail than what's been said already in terms of the servicing of that, but what I'd like to raise is the Waikato West side has been extensively included in what's called an integrated catchment management plan with the Te Awa Lake site that sits within Hamilton City Council as part of the same catchment for the expressway went through. It was part of the consent program, so it's actually linked through to the site by supply underneath the highway.
Do you have residual alligator weed issues on your side of the expressway? You're lucky. You don't have residual alligator weed issues on your side. Not yet. Yeah, right.
So that's been put forward to the Hamilton City Council and Waikato Regional Council. discharge consent, which is going through the final places of climate information to say rehabilitation and sufficient passage issues with the discharge of the Waikato River. So it's and the stormwater management and controls of the Hokitu West side quite extensively documented.
So the management plan you've done for the area being developed, you've done, you say you've done quite a lot of planning for the Hokitu land as part of that because of the integration of stormwater issues.
Yes. Yeah. Okay, John's wants details about that, so that's fine. Yeah, that linked together, so it's part of the treatment for it to a certain degree to be part of the highway that's about, which is a council, the other lakes side, discharge the Waikato.
So any stormwater reporting done for the Hokitu land does need to include or address these upstream and downstream issues.
Yeah.
That's really, well, it's, we can't separate them.
Yeah, correct. So yeah, that Hokitu West block that essentially drains towards the highway at the moment. The national school has been addressed by the catchment. That's a discharge consent. That's been granted. Obviously, that's process.
Okay.
And guess no. All right. Danny?
Good afternoon, Commissioners. My name is Slowy Rebet. It's Jeremiah without the J, without the H. Just in case I'm trying to spell that. But
Oh, it's so much easier.
So I'm the development director for Te Lakes and also for Ferry Group. So I've been involved since 2016. Sitting in for Richard, so he and I started the development together. So it exists on 3 blocks of land, of which this is the one that sits on the district side. So we've had the privilege of dealing with all the councils in this space and the different sets of rules that apply to those blocks of land. The vision is a comprehensive one in terms of an integrated master plan community that seeks to remediate the land that areas that were used for several years in conjunction with consultation with our tongues of people working groups in that space to come up with a new destination for the region, which is something to do with leisure and tourism, leveraging the unique location of the gateway to the city in conjunction with new way of living. So this is the first time we get to put this level of density, mixed typology into a regional context on the boundary of the 2 councils, and with an opportunity to introduce some affordability into that environment as well. So this land on Hokitu West, as we refer to it, and Hokitu itself, is our opportunity to bring our integration concept across, connect up the school, connect up public areas around the council in that space to effectively link all of those land blocks together and produce some 2,500 homes, a new village concept in that space, and a new tourism precinct for visitors.
Not relevant to our consideration, but what's the intention? How are you going to negotiate the divide that's the expressway in terms of integrating those 2, Te Lakes and Christopher?
Sure. So we have a connection already which goes across the river, so the Te Awa cycle and connects those 2 blocks. We have a discussion with Fuataki at the moment in order to, whilst they're doing some remediation work, we're also looking at trying to encourage them to consider an underpass, not for vehicles but for pedestrians. So encourage the multimodal transport and walking and cycling aspects.
Good luck with that one.
Yes, since we started in 2016, I think the word of possible kept coming up. So
remediation works, what sort of works are they generally, what's being remediated?
So on Te Awa Lakes itself, it's an old sand quarry. This part of the block was part of that original sand quarry. In the Te Awa Lakes area on the Hamilton City side, we've had the challenges of alligator weed and liquefaction in that space. We're also challenged with putting better quality water back into the Awa along our waterway, which collects a lot of our stormwater, which far to west supports charging of systems. And that's why the integration. If I can just, the remediation piece is the difficult one, so we can't do anything on earthworks until we've stripped the land of 2 meters of dirt, found alligator weed, buried it, and then commence our earthworks from that point. And in some cases, that's 8 to 10 meters below its finished level. So we added close to 500,000 cubes in that original process of discovering alligator weed. And then we've added probably another 2 years because of the way that we're dealing with the liquefaction issues on predated site in some spaces. So we're expecting and hoping that the Horizon West is a lot easier than that. Okay, thanks for that. Right. Thank you. Thank you.
And we'll get some words from you in due course, obviously, as you shovel back and forth on that. Thank you very much. Thank you. We can now flick the KO.
Good afternoon, sir. Can you hear us?
Can indeed. Welcome, both of you.
Thank you. Kia ora. We'll try to, oh, somebody's Teams video is coming in on me. I'll just close that down. Mr. Rice is chasing me out, I think. Well, somebody is. Thank you, sir. We're here to speak for Kāinga Ora. Ms. Gunnell has given you, I think, a fairly good summary of where things have got to. I presume you've read through the 2 statements of evidence from Mr. Campbell and the legal submissions from me, so we won't repeat that. It takes some doing to get these 2 organisations to agree on the matters of details that we have. So, and it's a finely balanced outcome, but one that everybody seems happy with. So there was a little bit of concern when we got to the point.
If you were more amenable, agreements would be so much easier.
That's right. That's right. But habits of a lifetime. So we're in a position where we were a little surprised when we got the, I guess, the reports prior to the hearing, where new things appeared. And that's the focus, if you like, of my submissions. There were 2 issues in particular that we addressed. The first, and if I just quickly take you to it, the first was the proposed objective MRZ 210 and MRZ 2 policy 16. And this is where we have site or zone specific objective and policy to support the revised rail setback. And the issue there was the rule applies through all the zones. And there's some oddball things in this plan where sometimes there are provisions that refer to specific zones and not all zones. But clearly, if you're going to have the rule applying to all zones and you relied upon an existing policy and objective structure to get you there for 4 or 5 zones, it's going to be applicable equally to the last zone that you're adding in, the MRZ2. And the concern we had was that if we're adding in sites or zone specific provisions, lawyers will tend to look for distinctions between zones. And if you have it in the MRZ2, but you don't have it elsewhere, they'll say there must be a reason why it's not somewhere else. And one of the interesting things I think about the summary paper that Mr. Butcher put in for you was that she almost I think, indicated that that was the sort of outcome we're looking for in terms of policy 11, that there is in some cases some particular concern with the MRZ zone, 2 zone, that is greater than in other zones. And I think if you're going to have that kind of thing in your plan, you have to be very clear about it. And it's probably going to lead to a stronger rule in the zone that you're more concerned about than it is in the other. But in this case, we have the same rule applying across a number of zones. And if the policy framework gets us there in the existing zones, it should be enough to get us there for the new zone. I'm not saying that the council shouldn't go back and have a look to see whether at the end of this exercise, maybe there's some tidying up it ought to do of policies generally. But I think if you toss in a specific objective and specific policy for the MRZ2 zone, you're going to have an issue with lawyers looking for why it doesn't exist elsewhere. And you then create a problem for yourself that I don't think you need, because the policies, as we've explained in our evidence and submissions, deal with safety and efficiency. They create the rationale for the rule that we're dealing with in terms of the setback, and that is an appropriate mechanism already in place. So that was the first issue. The second issue was how we should, if we should amend policy 11 regarding reverse sensitivity. And as I've said in submissions, the reading or the exercise that Kaingaora has gone through with the transport authorities and the council is that it sees the provisions we're dealing with as relating to safety and efficiency. It's not a reverse sensitivity issue in this case. And Ms. Gunnell put to you the wording that had been reached subsequent to all the documents being exchanged, which included reference to Havelock. It could include reference to Horatau if that was deemed appropriate. It may well be, though, that you have a zone-specific or a site-specific provision already in the plan dealing with Horatau, in which case you wouldn't need to bring it back into this one. Havelock, sorry, with Havelock. So there's a consideration to be given there as to whether it needs to double. But if the provision, the policy 11 bracket 2, reference to design controls, is actually here to deal with some specific areas, let's say it. And it avoids debate, and it avoids, again, people going down rabbit holes in the case of a resource consent in the future about what the policy means. So from our perspective, simplicity and clarity are desirable things, and we think there is a way of doing that, albeit that the council might want to come back later at the end of this exercise and say, let's make sure everything ties up and the boxes are all well confined. I'm not sure, sir, if I need to say anything much more than that in terms of summarising the position we're in. If you've got questions, I'm happy to answer them. Otherwise, pass across to Mr. Campbell.
No, I mean, we're clear what both of you are asking for, or the points that you're making, I should say. I mean, Mr. Campbell, I don't know whether you want to elaborate. I mean, it's there in front of us. We know what the point is. Over to you.
Thank you, panel members. Yeah, I don't really have much more to add. I've had an opportunity to listen to some of the conversations going on this afternoon, and Mr. Allen has kind of summarised the position, and I was able to listen to Ms. Gunnell in terms of her suggestions around the potential changes to policy P11, which I think, subject to just clarification in relation to Havelock, I think those changes are fine. And yeah, I'm happy to answer any questions, but I think it's pretty clear in terms of the position.
Yeah, no, thank you for that. And I mean, we'll just get the words back and make up our mind as to what we think at that point. So, yeah, I think good on that. So, thank you for your time once again.
Thank you very much. And thank you for allowing us to not travel down today. We're very grateful.
Yeah, right. Okay. Right. Finally, I think, well, not finally, but last, going to Havelock, I think. Yes. Zebit, welcome.
Thank you. Good afternoon. I am just tracking down Mr. Tolomash as well, actually. I had asked him to join me. He's been working with Ms. Laputri on the provisions, and I thought it might be helpful if he was here, just if you had any questions on those, now that you've seen the joint witness statement. You'll have to be slightly, I've been texting him frantically as the proceedings have advanced at a rapid pace this afternoon. So he assures me that he will be available, and hopefully he was following his phone. But you'll be conscious that things have moved at pace today and swapped around a little bit. So I will do my best in the interim. First of all, I just wanted to say thank you very much to the panel for accommodating our last minute flurry of documentation and request for an appearance today. We're very grateful for the opportunity, particularly in the circumstances where things haven't quite landed where we'd hoped. Although I have to say that the imminent deadline of this hearing was certainly helpful in collecting the last few signatures on the consent order. So grateful for that as well. Oh, here he is. So I'll just wait for Mark to join us. As I heard at the start of the hearing, you're right, there's a lot of things that have changed since July, some perhaps not good and some others great, and one of those is that we've reached a settlement on the entire Havelock precinct and zoning provisions under the PDP appeals, which has been a really great outcome for Havelock as a whole. It's meant that we can sort of deal with the site and the zoning and all of the provisions in a holistic manner, which has been a great outcome for our team. What it has meant in terms of this process is that the, I would guess, partial piece of the precinct that we had brought to you in July, we can now hopefully, subject to the court issuing the final orders, and we had some positive indication on that this morning, bring the final piece of that back to you as a relevant residential zone and put to you what we see as the final piece in that puzzle and apply the controls across the board. Subject, of course, to your decision as also as qualifying matters. So I just really wanted to provide an update on that. Obviously, we've filed various pieces of paper to assist you through our thinking on how that fits together. You've had an opportunity to read that, I hope. So I guess I'm in your hands as how you would like to, how you want us to take you through all of that.
Well, I mean, the key thing that I'm interested in is any translation exercise we need to go through between what you've agreed to through the PDP and what we might be looking at. Because, I mean, some of the, for example, and the thing I mentioned this morning was one of the issues that we're likely to be, or has been put to us as an option for removal is the Environmental Protection Area, the EPA.
Yes.
And yet the EPA is clearly signalled and referenced in the provisions that are now coming through in terms of the PDP, at least in terms of the addition that we've been provided through the JWS. So I assume that that's still there.
Yeah, no, I can. Yeah, no, that's helpful. I can definitely answer that. Yeah, and anything.
I mean, and there are other. I mean, it's the minutiae of those things that we need to be looking at. So
right.
What can you advise us in terms of how we should take these provisions and consider them within the context of the IPR?
Well, I can talk to that at a big picture level, and then if there's any minutiae that you're still not convinced on, I see Mr. Tolomash is available, so he can take you through that. Essentially, this precinct and zoning and has always been master planned as one site. So we've worked on it collectively the whole time, irrespective of the fact that we've only ever been able to bring, one chunk of it before you in July. So from our perspective, with the provisions have always been one set of provisions, even though we could only break off a piece and bring it to you in July. And I guess it's behind the scenes, but for us working on them, they've always been a set of provisions. So after the hearing in July, we took what we had put to you back to all of the PDP parties. And hopefully you will have seen from my memorandum that the variation 3 parties were just a subset of the bigger set of parties we've been working with. And we've effectively rolled that out across the whole of the precinct and zoning. So we took that as our starting point and worked that across collectively across the whole precinct. So essentially the variation 3 provisions and the qualifying matters or controls became the new baseline for the site in totality. So we've worked with all of the appeal parties on the basis that we would ultimately go for a uplift in intensity. We've developed all of the controls to match what we did in variation 3 for the piece we brought to you in July, with the understanding that we would ultimately try and get the uplift for the new piece once we got it rezoned. So it's been completely developed with that kind of collective vision, and on the basis that we would manage it that way. And that's recorded in the consent memorandum, which was signed by all the parties. I think you can have quite a great deal of comfort that all the provisions have been developed with that in mind, and we have faithfully translated them over from the consent order version to the agreed joint witness statement that's been presented to you today. So then from an evidential perspective, the only piece that we actually needed to add from a statutory basis to this proceeding was to qualify those provisions, because they're identical, was to qualify those provisions in terms of section 77L for the purposes of this process. If that's where conceptually we felt that needed that extra statutory layer.
All right, well, I mean, obviously, until we actually sit down and work through the provisions, we won't know whether we agree with you or not on that one. But
No, quite right. But so that if I could just summarize, the provisions that we put to the court are the same provisions that are put to you, with the additional layer of the joint witness statement that qualifies them in terms of section 77L, if that's a nutshell. Yeah.
Yep, no, thank you for that.
I will mention one thing which did get raised this morning. Judge Tapania has raised a question about an assessment criteria, whether there should be a specific reference to one term. We'll probably go back and say, well, whether it's strictly necessary, yes or no, but you could add this word. And one of the directions that we sought last week was, could we leave the hearing open to deal with any such consequential amendments? And I think this is exactly why, because we, as I said, as a team, see this, there's in our minds no difference between the PDP provisions and what you have. So we would like to, and our agreement with the parties has been made on that basis. So to the extent that the court dictates a different set of criteria, we'd like to feed that straight back through to you.
Yeah, that's fine. No. And as I said, we can, at this point, we can stay open until the end of January. And after that, depending on whether the reporting time gets changed, we'll just have to see. Yeah.
I think the court seems quite open to a quick decision, if I may, touch wood, fingers crossed.
That's a very bold assumption. It's right. Okay.
I just said they seem open. I think that was a very caveated assumption.
Yeah.
Just if I could answer the EPA question as well, because it's an interesting question and one that I do want to address. Your recollection is correct. We did seek to remove some EPA, but I just wanted to touch on that because it's only some of the EPA, and it was only a very small portion as it related to Area 1, actually. Yes. So the vast majority of the EPA will remain, and that was always part of the agreed provisions. There's quite a considerable amount of EPA as it relates to the entire site, and that was never envisaged to be removed. And this is where I might need Mark's help, Mr. Tolomesh's help. My understanding is that that piece to be removed will be shown on the mapping that is attached to the joint witness statement as removed, because that has been agreed by everybody. And the EPA that is shown on the joint witness statement reflects what is agreed and should be carried forward into any decision. But maybe Mr. Tolomesh could jump in and confirm.
Right, well, I mean that goes to the point that I was actually focusing on, which is that the which is that the map that we have, which was the one that came through yesterday, the post-appeal version, doesn't show any EPA at all.
Okay, I'll
So-
hand to him then.
So it might be helpful if there is still EPA, for that to show as well, basically on that particular map. So
Mr. Chair, Mr. Chair, if I can, on the JWS, page 23, so it's the second last page, that is the precinct plan, where the map that you possibly saw was the map either on page 21, which is the zoning plan, or just to add a little bit more complexity to this, the
Yes,
map, appendix 3, page 11, which is the qualifying map.
Not much, just a second there. Yep, no, I can see that the EPA is on that map on page 23 on the precinct plan. I guess the question is if we're going to have a map within our decision, is whether or not that map, the map that we use, should show the EPA as well, just to avoid any confusion. So just let's get a complete map, shall we, between you and us.
Yes, we can work on that. That's fine. I can speak to the council team on that. I think that would be.
It may well be that you decide that in actual fact that the precinct plan is actually the map that we should be using. I mean, that's entirely up to you as to which you think is the more appropriate map to come in.
In that respect, Mr. Chair, that is actually correct. All the detail that is in the consent documentation is on the precinct plan. The only difference, obviously, that comes into play is variation 3 is just dealing with the residential zones, and that precinct plan addresses all the zones, and the overlays cover many different zones. There's rural lifestyle, there's rural zone, there is open space zone in there as well. So there is, we can produce a map that provides that clarity for you, but all that is missing from so the map on page 11, appendix 3, qualifying matters, yet it's only the EPA that is not included on that one, and that's on the basis that it was a map of the qualifying matters themselves, not a map with all the precinct details. For example, the precinct plan includes where the indicative roads are.
Let me put a slightly different question then to you: is what should the map that we include in through PC9 through this plan to variation 3? I'm in the wrong hearing. Variation 3. What should the map look like? What should it contain, or should there be one at all?
I believe the map should be the map of the qualifying matters in appendix 3. That's what so the first part of it would be there is a rezoning map just dealing with the residential zones. The second part, I think, is the map of the qualifying matters. I think for information, there could be a map that is the composite of all those factors together for clarity, because this is multi-layered in terms of the way that the overlays work. And I think the best way is they cooperate or integrate with each other. So the third map would be wrapping it all up together.
No need to go any further then. I just invite you and council to get together to produce those maps and just simply to provide the maps to us that you think work best for the variation.
Yeah, thank you. And Mr. Chair, that's a helpful indication, and we'll come back to you on that.
Yeah, I think I just want to know that the EPA has been replaced by all these other things. And if I was going to refer to something, i.e. a map, I just want that there so that someone reading it could produce that as well.
Yeah, no, that I understand the concern. It certainly hasn't been replaced. It's just not a qualifying measure as such. It's a planting tool. We spoke to that in July. I understand why it appears that way, but yeah, we can cover that off and come back to you.
Yeah.
Thanks.
Otherwise, I think Well done.
Thank you very much. I just
right.
actually check. I had a few points that I wanted to make sure that we covered off. I just will take a moment. As I said, I think there might be one assessment criteria we'll need to come back on. I think that was, oh yes. Actually, I did just want to note for the record that Ms. Nian for Hines has also had the opportunity to consider the joint witness statement prepared by the reporting officer and Mr. Tolomash, and confirmed today that she's in agreement with that, and that I could report that on behalf of her to the panel. So I just wanted to pass that through. Also just wanted to indicate on behalf of Hines, which I've also been authorised to do, that they're in support of this position.
Sure.
I did prepare a second memo, which I filed last night, just outlining the sort of the overview or overlap between the various parties. I hope that was of assistance, and just wanted to check whether there was any outstanding questions in relation to that.
No, I certainly noted that. Thank you very much. I think this is, yes, we're good for that.
Great. Appreciate that. Well, thank you very much. Appreciate your timing.
All right. Thank you.
All right. Cheers. Bye-bye.
Thank you. Cheers.
Have anything else that we need to talk about? That's it. We're back to you.
That's it. Yes. So given we haven't seen some of that wording, it's a little bit hard for me to do a reply. Perhaps I do that and writing it will be brief. The matters I've noted for that is the assessment back for the flood maps, to look at the policy given that's been agreed between Kind Water and Water. The reference to Horatu makes sense. The second objective of policy, which we will find in setback, and in the wording for the exemption to NHR rules 1921, and then what at works text for inclusion of variation training for the operator. I think that the outstanding issues that are picked up from today. Sorry, Ms. Hill has just raised with me that since the July hearing, and it may have been in response to the evidence of Collingwood, looking at some of the natural hazard rules, that we found that they were somewhat overcomplicated. So in response to the evidence, the rules have been provided to the business incentive team to look at in terms of their ruleability. And the feedback we've received on some of those rules is that they were looking benefit from some refinement. The issue, of course, the procedural issue that raises is if we were to make amendments to them and supply an updated version to the panel, the other submitters haven't had an opportunity to look at that. Now, there is the option of circulating those provisions to the other parties and asking for their feedback, and providing colour coded, updated provisions. This is green is agreed, yellow is not agreed, and this is the reason. Interested in your views on that. I think my advice to council is that any refinement shouldn't change the substance of those provisions because they have been through the hearing and evidence process. It should just be, refinement to make them.
I mean, if it's finessing wording, I'm not sure that needs to go up for public reconsideration, really. I mean, there's a judgment call there also. There's a judgment call as to how far refinement goes.
And of course, that refinement process hasn't taken place yet, so it's difficult to say whether it is anything or it is going further. Until that's done, I don't think.
Yeah, no. So time for that that process. I mean, is that going to be done before Christmas, or is that more likely to be March, April?
I think we could try and do it before Christmas.
I think that's what I'm hinting at. I think very strongly because
Ideally,
because I mean we obviously need to see that to make a call as to whether we think it goes too far in terms of more than just sweetening. So if you can do that over the next couple of weeks, or maybe when you've done a chapter or something like that, you throw it to us and say, well, this is what we're doing. Does this look okay? Then we can give you feedback. But certainly, I personally will encourage that to happen. But less complexity, all the fewer compound sentences in the rule, the better. And I can tell you, one of my commissioners is just so vicious when it comes to looking at these sorts of things. In a nice. Yes. No, I wasn't particularly. Right. I mean, in terms of a reply, I'm assuming that's going to be in the new year. Or were you planning, or were you thinking also of replying before?
I'll do that.
Okay. Okay.
Get a whole idea.
Yes, yes. I mean, you'll obviously then have a subsequent to do when we get whatever might come back from the court. Which will be a small comment, I suppose. If we need to do anything, I mean, I don't know, in terms of what Zeb was talking about, whether that assessment criterion is even going to be on our books. I mean, it's going to be in the plan, isn't it? I don't even know whether it's relevant. I'm sort of a little unclear as to exactly where this is going to sit in the plan, whether it actually sits entirely with us or whether it sits. So maybe it'd be helpful to give us some guide in terms of that. I mean, yeah, I'm just trying to think what's the minimum that we could get away with doing from our point of view, which isn't going to create translation issues. PDP. It may be just on that, bring it into NRZ2. I mean, let's try and uncomplicate our lives and complicate yours.
Wait.
That would be my preference.
Understand.
All right. Well, I think we're done, are we? Yeah. See, there's nothing more. Nothing more. No?
did you want to close or do that? It's not about
Mai te kāna. O pena mō koutou katoa. Ai, ngā mihi nui ki a koutou katoa i tō tātaitanga, i tō kōrero tōna ki te rānei. Me hakakapi tātou i tā tātou uhuanga i te rānei kei te kakia. kia tau te manaakitanga, ki runga I tēnā o tātou. Kia piki te ora, kia piki te māramatanga, kia hoki pai atu, kia hoki pai. Tuturu hakamaua kia tīna, tīna. Haumia hui e tāre ki.
Okay.